Recently, I came across a judgment from the Madhya Pradesh High Court, and the case number is miscellaneous criminal case number 54170 of 2023. The judgment was pronounced on 4th of April 2024. In this particular case, the husband was denying maintenance to the wife on the ground that he is from an Orthodox family, and the wife was supposedly a modern girl who was uploading a lot of photographs on Facebook. So he said that she is living a very modern lifestyle and I don't want to give her maintenance. Obviously, the court didn't allow this petition, but there is an interesting discussion to be had here in order to provide more clarity on the matter. For this, first we need to look at the Delhi High Court's judgment in the case of Bharat Hegde versus Saroj Hegde, where it was said that the maintenance amount should aid the applicant to live in a similar lifestyle as he or she enjoyed in the matrimonial home. This was affirmed or followed or reiterated by the Supreme Court in the case of Rajneesh versus Neha, which is a landmark case in respect of maintenance. Now, how do you interpret this term lifestyle in these cases? Basically, I am of the opinion that the interpretation of the word lifestyle here must only be with respect to the gross amount required by the wife in a month with respect to her basic amenities like food, clothing, health, so on and so forth. But it cannot be giving the husband a free hand to determine what kind of food she has or what kind of clothes she is wearing. Now, to explain this further, you can imagine that when the wife was with the husband, say she was a vegetarian at the time, and the expenses incurred by the husband was around X amount at the time of their marriage. Now, after being divorced or after being separated, the wife can still have that X amount for food, but with that X amount, she is entitled to have any kind of food. Likewise, with respect to clothing, suppose she used to get a number of clothes every few months or every month for that matter. Now, after divorce or after being separated, within that amount or with the same amount, she is entitled to get any dress she wants. So that is how I think we should understand the term lifestyle, and the husband cannot be allowed to determine what food the wife has after they are divorced or separated. For that matter, he cannot determine what food she has even when they are together. So this is for the wife's side. She can fight that ground as long as she is able to prove that she is living such a lifestyle with the same amount which she used to have at the time of her marriage. So it's like I used to have X amount for food at the time I spent with my husband. Now I require the same X amount, but with the X amount I am entitled to do whatever I want to do. Likewise, on the husband side, I think the right argument would be that okay, she is living a lavish lifestyle. She is spending X plus Y amount right now on food or clothing, on gadgets and all that, but she was only spending X amount when she was with me. So now she has enhanced her lifestyle to an amount that is greater than the amount that she used to spend while she was with me. So that is the argument that the husband can put forth, but one cannot go forward with the argument that I'm an orthodox person and she's living a modern life and all that. But it all comes down to the gross amount spent at the time of marriage, gross amount spent or required after marriage for maintenance. So it's gross versus gross and not lifestyle in the sense of tradition and all that. I hope this video was useful. Please do subscribe to our channel, follow us on Spotify and YouTube. If you're interested to read more legal articles, do subscribe to our digital law magazine. Stay tuned.